Because they believe that's why we have the First Amendment, freedom of speech. That if people were able to get the public square, they were able to articulate these things and argue and debate, then guess what? The truth ultimately comes out. What you see today is a real attempt to stifle free speech. That's why we have colleges out in California. You're going to fight that person? We're going to burn the place down. We're going to kill people.
That's all I say. Hit them on the hand of God. My hand of God.
We're not going to allow you to have that.
I told her.
What you doing, Miss Sheila?
You know what he says? There's only so much we can talk to each other about. Okay, that's heartless.
Hey, how you doing?
You're all prepared with something to take notes on?
I don't want to be accused of misunderstanding.
Oh, I don't mind that. That's like my defense. I'm sorry, I misunderstood the question. I don't want to look different from you guys. So
well, that's.
I'm going to give in to the peer pressure.
I figure it looks more professional.
That's right, maybe.
Maybe try to get bonus points. He had a yellow tab.
He had a what?
He had a yellow tab.
Yeah, right, there you go, right, yeah. It's the yellow that does it too, that sets it off.
It says caution.
That's right.
Go ahead,
Good morning, ladies and gentlemen. Welcome to our fifth in the series for Constitution Day. This is actually our second in series for a roundtable discussion. The topic today will be the Constitution. Specifically, the topic will be the Bill of Rights, the first 10 amendments to the Constitution, which Representative Zedler was alluding to in his presentation in the first hour of this series. So we will be looking at the first 10 amendments to the Constitution, known as the Bill of Rights. And the question for the panel is whether they should be updated, quote unquote, reworded, quote unquote. Are they relevant today or are they irrelevant today? And of course, our panel includes faculty from history, government, and philosophy, and I'll let them introduce themselves and we will start. Please.
I'm Liz Inslee, and I'm assistant professor of history.
I'm Jenny Jones, instructor for government and history.
Nick Pugh, instructor for government.
Greg Trickett, philosophy and ethics.
Bill Zedler, state representative.
Okay, so let's. This is an open forum, of course, and so it's like one large Q&A session. So let us look at the amendments to the Constitution, obviously, and we have the people pass out the mini constitutions yet. Could we pass those out? Have they been being passed out? So. You know, when we look at the Constitution of the United States and we look at the different amendments, and Representative Zedler was pointing out some things that the first 10 amendments do provide. And one of the things is that the first 10 amendments to the Constitution constrain the national government. Obviously, they're put in there as a break, as a safety. That is a starting point for us to examine them, because if you look at the 10 amendments, or the Bill of Rights, which are the first 10 amendments, there's a lot of words in there, and most of the words are will not, shall not. So it's a constraining device on the national government. So we want to kick that off. Ladies and gentlemen, if you'd care to make some comments on a particular amendment, your views, please, and of course it's an open forum and the audience can participate.
I'll make a comment. As far as them being restrictive clauses, in case there was any doubt, there is a preamble to the Bill of Rights, just like there's a preamble to the Constitution. However, in a lot of printings of the Bill of Rights, that preamble is left out. And just in case you didn't catch it in the 9th Amendment or the 10th Amendment, the preamble at the beginning says, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. So they are definitely restricting the government.
Well, yes, they're there to restrict, but the problem that oftentimes we see with new students when we're looking at the first 10 amendments is that there is an error in thinking, the presumption that somehow the federal government is giving you rights. You need to erase that from your thinking as we move forward in this discussion. These rights are not given to you by the federal government. They pre-exist the federal government. If you read cautiously and carefully, you will see that the founders believed that these rights were given by a creator. They are inherent to the nature of being a human being. And if you accept that as true, then the only way to read the 10 amendments is an attempt to protect rights that you already have no matter what. And if you can't get your head around that philosophy, the discussion will be complicated.
I would clarify that it's not incumbent on you, however, to believe that there is a creator.
That is correct.
Right? So the framing fathers believed that these rights were endowed upon you by a creator. But it's not incumbent on you to believe that there's a creator, to believe that your rights are inalienable, that is, that they are a part of the fabric of who you are. You could come to the conclusion that rights are inalienable or rights are inherent, as he said, a fabric of the structure of what it means to be a human being without a belief in God. Now, I say that as someone who does believe in God, but I think that's important because otherwise there could be certain abuses towards those who tend not to believe in God.
And to me, as I look at what's going on in America today, I think one of the greatest problems is that there's an attempt to squash freedom of speech, the First Amendment, and like for instance, where there some universities they're now saying, well, you know what, you invited a speaker, but we don't think that we can. There's this group out here that's threatening violence, and we don't think we can have enough police protection to prevent the violence. So we're going to have to disinvite that individual. I think that is one of the greatest threats to America today. The second thing is political correctness. I think political correctness it's a real threat to America. It is, and the whole idea of the First Amendment was they wanted a free flow of ideas, people be able to debate and argue things out in the public arena. And one of the great threats is when you have a position and people say, well, you're a bigot, you know, that kind of thing.
Or I'm offended by that.
Yeah, I'm offended by that. And I want to tell you right now where that comes from. There's a book called Rules for Radical by Saul Alinsky. Saul Alinsky was a self-admitted Marxist, and what he said was, do not get involved in debates. What you do is you make the person who takes the position, that you make them the issue, and then you target them, and then you use words like bigot or whatever. Because why? The idea is to stifle debate. In free societies, you've got to have open debate and things like that, or what happens is you end up with the opinion of the tyrants, or who are willing to use violence to shut you up. So,
Professors, I see your wheels turning.
When you think about how far, honestly, how far some of these concepts and these ideas and these notions go back, because they were a precursor to a federal government. They were a precursor to any document ever that was written. And the notion, the concept of the First Amendment of the Bill of Rights, freedom of speech, press, religion, expression, privacy, came from the Enlightenment, which, again, part of the Enlightenment is a belief that there is a God, but he's very impersonal. He's turned his back. He is left it up to us and us alone to move forward. And there is no limit to how far we can go and what we can create, but we are on our own. And why they do believe there is a God and there is a being, it is more of a philosophical movement. But concepts like freedom of speech and religion and all these used to be an inspiration and changed lives. And as history has gone on, instead of being an inspiration, they're becoming more of a hindrance as we become so much more political than we used to be.
Well, I'd say I'm sorry. Go ahead.
I was just going to point out, I think someone had a question.
Yes, there was a question from the audience. I'm sorry.
So regarding the Bill of Rights, I was under the assumption that because, say, if you are a felon, these rights can be taken away from you, that while we do have unalienable rights, the Bill of Rights are more of the government restricting itself by giving you these rights that cannot necessarily be taken away. Not that they are unalienable, but that the government has forfeited its right to take them away from you. Not that unless you forfeit your right by having them by breaking the law. Not so they can be taken away.
But only with due process of law.
Right.
Yeah, but so I can't forfeit my right to happiness or my right to living unalienable rights if I break the law. I still have you know what I'm saying? I still have that right unless I do something completely horrendous. So does that?
Right, and it's that unless that's important, right? So it's the idea that the rights are not given to you by the state or by the government, and they're not even so. I would imagine that the philosophy would be that they're not even taken away by the state per se, but rather you give them up when you offend the public in a certain way, or when you violate the laws in certain ways, right? So, I mean, one of the obvious ways, if you infringe on someone else's inalienable rights, then you give up your rights.
Right. And
the state doesn't take them away as such. They just recognize that you've forfeited your rights to some degree, and then the consequences follow.
All right.
So I guess another question that we need to address is if we are reinterpreting the framework that was established by the founding brothers of this country, right? What specifically, if that is happening, if we can agree that that is happening, I guess, maybe that's another point. But if that is taking place, then specifically what amendments in the first 10 amendments are under attack today?
The Fourth.
Why?
The Fourth Amendment is under attack because we gave it away. I mean, it's apropos that we're having this discussion the week that we're celebrating or acknowledging the 16th anniversary of the September 11th attacks. But after September 11th, we were terrified, absolutely terrified, justifiably so. And we simply said, seriously, anything you need to do, do it. And the consequence of that is ultimately a chain of unchecked powers being given both to the federal government and to local and state governments as it applies to their policing power.
You're addressing the USA Patriot Act?
Well, the Patriot Act and many other cases where we have seen an expansion of exceptions to the Fourth Amendment as it applies to searches and seizures. And I think that that's the real threat. While it is true that the First Amendment certainly takes a beating from time to time, the real threats and this is just my opinion, but the real threats come from the places where there is an individual who can exercise authority over you that you cannot exercise over them. That's the real threat. And we need to, I think, cautiously watch the courts and see how the Fourth Amendment is either shaved away or taped back together.
Comments, panel? Any comments?
Yeah, you know, I agree that that's a real problem, and I see it with a lot of even state agencies, where, and I'll just give you a classic example. We had a nurse investigator with the medical board went into a doctor's office, had an administrative subpoena. She had 3 other people with her, had an administrative subpoena for patient records. The nurse gets the patient records, brings them out there, but she says, we're with the Texas Medical Board. And she has an administrative subpoena. And all 4 people go in the back room, start looking through the patient records. 2 hours later, the attorney for the doctor gets there and finds that 2 of the people there are DEA agents. Okay. Now, here's the deal. The attorney for the doctor picks up patient records, says this meeting's over with, puts them back in the files. 2 weeks later, an attorney for the DEA goes to court, tries to get access to the same medical records. And when the magistrate says, what's the purpose of this? They said for possible criminal prosecution of the doctor and some of the patients. And that means that the DEA used fraudulent non-disclosure to get access to your patient records. And then they were going to use that to go after you. And when I brought this up in a public health committee meeting, the executive director of the medical board admitted that they did it 20 to 40 times a year and had no problem with it. There is the danger, is these unelected bureaucrats with the power of the state behind them that are violating people's rights. And let me tell you, it's the only thing that can happen is if the legislature is willing to step in and stop it. And the deal is there's powerful interest groups out there that like it the way it is.
Representative Zedler, you bring up something interesting. So we have FERPA here, which is some type of protection, and you're obviously noting a violation of HIPAA, which is for the medical thing. Okay, so in a wild imaginative state, could someone actually do that scenario to students and come in and have some type of warrant to look at their personal records?
You know, let me tell you, if they can get your medical records, that you know your student records, you know, it may be the teacher knows about them and stuff like that, and maybe people with administration. Your medical records, it's you and the doctor. That's what you think of. It's me and the doctor. So you're a lot of times willing to tell things to your doctor that it's like your attorney, that you wouldn't tell anybody. Okay? If they can do it in that case, beware. And
that's a scary thought.
Yeah, it is. And when they can have those kind of abusive powers, I basically ran with a bill that said nobody gets your medical records without either your permission or a warrant. Not even the medical board, because the medical board is immune from the HIPAA laws. But they shouldn't be. So,
comments, ladies and gentlemen? What about the other amendments? Let's look at maybe the 5th Amendment. You said the 4th is under attack. Let's address the 5th Amendment to the Constitution. Well, that's an interesting one.
Mr. Castillo, can I go
sure,
back to?
Please.
I want to go back to a prior to an initial, the initial question that you asked.
Sure.
And I think it's relevant here because whether or not an amendment is under attack or whatever, as with a lot of this stuff, is going to be largely a matter of interpretation, right? I imagine that depending on the political spectrum of the person that you're asking, they're going to say, well, this amendment or that, right? They're going to say either the 5th or the 4th or the 2nd Amendment is under attack, depending on who you're talking to. So there's a large part of interpretation here. And your initial question is, should the Bill of Rights be changed in some way, right? I think that was your initial question, or something along those lines. And I would say in response to that, and again, full disclosure, I'm politically conservative myself. But although a lot of people may interpret that differently when they hear what I have to say.
I know I have.
Yeah, as has other people in our band.
Yeah.
But yeah, I would say this, and again, this is coming from my religious background. It's no secret to my students or my colleagues that that I am a Christian, and I take that aspect of my life very seriously.
And a minister.
And yeah, well, yes, but yeah. So, so given that, when I look at the Constitution, I hold it in high regard. It's the backbone of our civilized society, to be sure. But it's not infallible. It's not Scripture, right? So given that it's not infallible, right? It was made, but it's not like, you know, you've got Matthew, Mark, Luke, John, all the way through Revelation, and then you have the Bill of Rights, right? That's not added into the back of my Bible there. It seems like, in theory at least, it should be possible to change the language. I would qualify that by saying this: any attempt to change the language should be in an attempt to clarify the language, not to take away the restrictions on the government or anything like that it places. So, but I think we do this in effect, even if we don't do it legally, right? We don't go in and actually change the language. We do this in effect in the public forum when we have these kind of debates. Yeah. When legislators get up and they say, well, we're trying to interpret it this way, and we're trying to interpret it this way, and, you know, I think that
or the courts.
That we should be, or the courts. Yeah. I think that we should be open to thinking about ways to clarify the language and get everybody closer to the same page.
I think the greatest threat is not us changing the Constitution. It's when the judges change the Constitution, because we're elected officials. Let me tell you, it's very easy to take out a state representative. It gets more difficult to take out a state senator, and more difficult to take out a U.S. congressman, and even more difficult to take out a U.S. senator. But it can be done. The deal is when it's changed by an unelected judiciary, okay, who all of a sudden find things that were, were quite frankly an anathema to our founding fathers. And I see that happening a great deal in the First Amendment, you know, and where, just like I say, the whole idea that of the government was they had the people have God-given rights, and yet here we have, quite frankly, an attack on the First Amendment, where we're trying to drive any religion or discussion of faith from the public square. You know, if I'll tell you, we open up our every day that we begin a session, we open it up with a prayer.
But I'm sorry to interrupt, but my question would be, you open it up with a prayer, would you open it up with a Buddhist meditation? Or would you open it up with maybe a secular,
no.
You know? And see, that's the issue, is that the First Amendment says we're not going to establish a religion, and it seems like when all we allow are Christian faith expressions within the public sphere, then we are establishing a religion by the government, or at least we're coming really close to it. It feels like it.
Let's ask Professors Jones and Professors Inslee. They're our resident historians here. Is that a trend historically? That's what's happening. Do you see that as an observation?
It seems recently we certainly allow expressions of other faiths in the public sphere, more and more so, even going back to 9/11 and the services after that.
Right.
But I'd like to go back further to the founding fathers, who actually wouldn't have called themselves the founding fathers because they saw themselves as improving on older ideas, not as founding something new. But they certainly didn't mind established religions at the state level. They did not want a nationally established church to protect against the kinds of corruptions that we had come out from under in the Church of England. But they overwhelmingly Christianity was the influence, and they certainly didn't mind it continuing to be an influence. If you look, there's a number of connections, even going back to, if you look at the the inauguration addresses, they were up until after 1865, they were overwhelmingly Christian.
Yeah, I mean, this country was built on the Christian faith, and there's many, many different chapters of Christian faith. I mean, you have, Protestant, you have Lutheran, you have Baptist, you have Methodist, but it was founded on the Christian faith. And I mean, since that point, I think we've always considered it's founded on the Christian faith, and for a long time, did revolve around the Christian faith. I think it's a mindset that's just become accepted, and historically, it's what we rely back on. But the evolution, the change of this country, and the different religions that have come in are newer and not as accepted or not as practiced, or the history of those religions in this country isn't as long or as old, I think. And we just go back to, this is how it was, this is how it's been, this is how this country was founded upon. It's been the predominant religion in this country for well over a century, and there might be a little bit of closed-mindedness there, but I think it's also just how it's always been, and it's what we go back to and what we rely on.
Also, where you run into a problem with some religions, because if you think about the Aztecs in Mexico, they practice child sacrifice as part of their religion. So they certainly, going back to the framers of the Constitution, they were not open as far as any religion. They would have allowed, I think, religions favorable, but they wouldn't have allowed anything in the name of religion.
Right, and that's not right. So the amendment, the amendment is not a carte blanche. If you can justify it with religion, you can do it, right? Because of course, in that instance, it violates the rights that we have. So, but it does seem like the Establishment Clause here is trying to get at this idea that we don't want one particular religious ideology to rule everybody to the exclusion of others. And of course, the Founding Fathers probably could not have foreseen the kind of pluralistic society that we find ourselves in. But finding ourselves here, the question then becomes, well, what is the spirit of this amendment? How should we think about this in light of this kind of pluralistic society that we live in? My fear, and again, I say this as a Christian, my fear is that saying, no, wait a minute, the fact that we're not allowing prayer in schools or these kind of in these public spaces, which I think is a little bit of an exaggeration. I mean, there are obviously public spaces where those things are perfectly fine, but like in schools, for example, saying, well, we've got to take the prayers out of schools, and that's, by the way, prayer is an individual practice, right? Nobody can take away your right to pray in a school. That's ridiculous. Until they put something in your brain that causes you to stop praying, they can't do that. So, but taking away this, led, directed prayer or something at the beginning of class, like I grew up doing, those who want to say, no, wait, that's taking God out of school and we should put all this back in. I think this opens a floodgate of the kind of, well, my religion wants to do this, and mine wants to do this, and mine wants to do this, and now we are infusing the school with religious views that some may object to and others may find offensive, and we're just infusing the schools with this. So, and this seems to be counter to what a lot of people who would want to have the prayer in school is really concerned about, right? So they don't want to say we want prayer in schools, they want to say we want Christian prayers in schools. That's what we really want. Because when the other ones come up, they say, no, wait, that's not legitimate here. And that's my concern with this half of the discussion. So.
Well, and we're focusing on the first part, but it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise of thereof, or abridging the freedom of speech or the freedom of the press. So it's really government, don't make any laws, any hands-off religion.
I've always been boggled by the conservative mindset that somehow government would be really good at religion in school and they're terrible at everything else. If, as a Christian, if you're conservative, if you really think that the government is bad at everything else, you ought to take a long and serious look about whether or not you want them involved in your practice of your religion.
We have a question.
Because I don't think I do.
We have a question here from this lady.
Okay, I'm just curious, because we're talking about the Christian. I'm Christian, so I have certain beliefs on things. So when the gay marriage laws passed, I believe it was in Granbury, a lady got terminated because she would not write out a gay marriage license because of her Christian beliefs, and she got terminated over it. So where would y'all stand with that? Because that infringed on her right of her beliefs and freedoms while trying to support someone else's beliefs and rights. So how would that come into play there? Because I would not want to sign that, but I wouldn't want to lose my job over it either. That's my income for my family.
Right. Y'all gonna look at me?
I don't think the state should be involved in marriage at all.
I'll take that on. Here's first of all, I think you need to separate what the Supreme Court decides versus what does the legislature decide. I want to make two delineations. Laws are done by the legislature. When people, like when John Kasich said, she need to follow the law. It's a Supreme Court opinion. It is not the law. The fact of the matter is, and let me give you a prime example. The Supreme Court decided in the Dred Scott decision that no black person could be a citizen, that they would be slaves. Abe Lincoln followed, thank you very much, I appreciate your opinion, I disagree, and I signed the Emancipation Proclamation. He freed all the slaves. So there you have a clear delineation between an elected official and an unelected person. And the fact of the matter is we said that's I think the greatest danger to America is where you have these unelected judges that come up with stuff out of thin air. And when the fact of the matter is this nation was founded on a Judeo-Christian worldview, okay, and that in essence that individual, they should have had accommodation for her religious, sincerely held religious view. So.
Well, I see people in the audience itching for another question. Young man, you're just itching to ask a question. What was that?
Can you defend other people's beliefs if they contradict another person's rights?
Well, that depends on it. Do they have a right? Does a gay person have a right to marry someone of the same sex? And where did they get that right? Because it certainly didn't come from God. So, therein is the difference. Where do your rights come from? Otherwise, was it passed by the legislature? It wasn't passed by the legislature. It doesn't come from God. So where did it come from? Well, it came from the courts.
The Bible isn't the word, isn't the law.
Let me tell you.
Could you repeat your response?
Pardon?
I was asking him to repeat
The
his
Bible
response.
isn't the law.
The Bible isn't the law?
Doesn't state what you can and cannot do. I mean, that's what the U.S. Constitution and the Bill of Rights are for. Give you.
And where did that come from? When it talks about the laws of nature and nature's God, where did that come from?
What are you asking?
Well, the Declaration of Independence talks about that we should have to us the laws of nature and nature's God. We ought to have the rights that the laws of nature and nature's God give us. Where did that come from?
You're going off of a primitive basis that because most people back then worship God, but what they meant was this is a human rights basis that you have rights as a human being, as a citizen of the United States, not by God.
Professor Pugh, I know you want to weigh in. What was it?
Well, I think, look, it is very easy, and I imagine exceptionally easy from the legislature to say, we make the laws, we know what they mean. But since the early 1800s, the standard in the United States has been, it is emphatically, look that word up if you do not know it, it is emphatically the province of the court to say what the law is. And that has gone relatively unchallenged, except oftentimes by the legislature and the executive branch. That could be corrected. We could amend the Constitution to prohibit the Supreme Court from saying what the law is. And for 200 plus years, we haven't. Because it's an important function of our government to have the fox tell you whether or not he should be in the chicken house seems contrary to checks and balances. Somebody needs a key to the gate. And oftentimes that key to that gate comes in the court. It is true that judicial review sometimes gets caught up in the idea of legislation from the bench. But the perception of legislation from the bench oftentimes depends on whether or not it went in your favor. And that's something to think about.
That's true.
Well, I think the difference is in the past, what's happened is when the legislature has said, no, we disagree, then they've passed laws, or like in the case of Abe Lincoln, he just said, thank you very much, I appreciate it, I disagree, and he signed the Emancipation Proclamation. Then what happened was the legislature came behind them, and then the people came behind it with putting the 13th, 14th, 15th Amendments in place that said, thank you very much, Supreme Court, but we disagree. And so there is a checks and balances, and it takes active participation on everybody as opposed to people just rolling over and saying, oh, the Supreme Court has spoken, as if it came down from Mount Sinai. It didn't. And so when there's disagreement, and I think that's what's missing much of today, we've kind of accepted the premise, oh, the Supreme Court said it, therefore we can't do anything about it. Nonsense. The problem is, in my humble opinion, we got too many people in the Congress who don't have a clue about the Constitution, don't have a clue as to what this nation was founded upon, and finally, and you see this a lot. They tell their constituents one thing, and then they get up there and they do something entirely different.
Yes.
So I want to make 3 quick points.
Yes.
To that last point, if true, and I don't doubt it is, I'm not saying that, but if true, that's the fault of the people. They should vote the bums out. So
agreed.
The second, and I'm not telling you who the bums are. I'm just. It's just what so, but I wanted to answer 2 questions that I don't know got answered. So. Laws of nature and nature's God, there's a twofold thing there. Laws of nature are not the Bible. They're the kind of inferred rights that we can see just by looking around, right? I mean, you look at the way the world works. It's what in my class we would call a teleological argument. I look at the way the world works. It functions a certain way. Certain laws naturally just fall out of that. And nature's God, the one who put those laws in place. Now, it was deistic, as Professor Hensley talked about down there. It was a deistic God, so was it connected to the God of the Bible? In some of their minds, yes. In some of their minds, certainly no. But that's where that is. To your question, I would say this. This is the question about the response to the woman who was fired over her moral objection. I don't know how to answer the question forthrightly, so let me give you a side analogy here. If in my position, I was hired under my position, understanding my job to be a certain way, and I fulfill that job to that extent. If at some point that changed, and I was asked to do something that I found morally objectionable by my religious convictions, and what I was being asked to do was lawful. Now, whether it is or not, I don't want to get into that. I don't know. That's for these other guys to talk about. But if it was lawful, and I was asked to do something lawful that violated my religious objections, I would not do it, but I would also expect to be fired.
But do you think that, and I don't want to throw, because everybody has their own religion, but do you think she would have had the same repercussions if she was, say, Muslim?
Oh, absolutely.
Do you think they would have fired her if she said, oh no, I'm not going to grant this marriage license? Because people want, You know, people expect the Christians to be so open to other religions, but I notice other religions aren't as open. They think that we're bigots and
absolutely.
that we're,
let me tell you this, because I work in these circles, and I go to debates, I participate in some of this kind of stuff, and the secular argument against religion is as vociferous against Islamic religion as it is Christians. I would suggest that if you don't see it that way, the reason you don't see it that way is because you're a Christian. I mean, obviously, you're going to feel the force of an argument against you if it's your beliefs that are being attacked. If it's not your beliefs that are being attacked, they're not directed at you. You might not even hear of them. But yeah, I would say absolutely they would have been fired.
Comments? I know Professor Jones was going to say something.
I was just going to say matters like gay marriage were supposed to be left for the states to decide. The states were supposed to run their own internal affairs. There's nothing about that in the Constitution, nor was that ever meant to be a federal law, those type of matters.
Honestly, the state should just get out of the marriage business altogether. If it's religious, let it be religious.
But taxes.
I know, but taxes. Money.
We have a question from the audience back there.
It's kind of a question and a comment, I think, because like this young man here that spoke that it wasn't necessary, could all of us comment about the Bible, but do you think that the generation, I'm a middle-aged lady here, the generation behind me, most of the time doesn't even know what the Bible says or believe in God, because we are living in a generation who downplays it. So they don't understand even that the Constitution is founded on that. So therefore they don't see a reason to vote against it, or like you said, because we're allowing things to happen because we don't really understand the Constitution. So would you think that that's probably true, because a lot of the generation behind us don't even believe in the Bible?
I think millennials take a beating, and I don't think it's always fair. I mean, I just don't think it's always fair. There's a presumption that somehow they're disconnected. And the truth is that their connections just are very different than mine. You know, I liked Duran Duran, and I was afraid of the Soviet Union. That doesn't exist anymore.
You mean Duran Duran?
Duran Duran.
Well played, Daryl. Well played. Their connections are different, and I think it may be a tiny bit arrogant presumption, at least from my perspective, to look at my millennial students and say, "Well, you are incapable of understanding because you didn't do it the way I did it." Because
No, I'm not
I'm confident.
referring to that. I'm just saying, do you think it's because there is a generational gap where I think first the Pussycat march on Capitol Hill, or whenever they went up there, you know, when I see that, I think sometimes they don't really, truly, not only their values different than I would say mine are, but have they really looked into or even know what the Word of God says?
So I would say this on that point. The fact that, and I don't think you're saying this, but I just pointed out, right? So the logic of it. The fact that someone, understanding what God's Word says and believing what God's Word says are two different things.
That's right.
Right? So
Right.
I think that I don't know that we can say that they haven't read it or don't understand it. Maybe they've read it, they understand it, and they found it wanting for various other things. I do think, and I'll say this personally, I do think that religion generally is under attack from a secular mindset. Now, I use that word, I don't mean that in any violent sense. I think ideologically, right? I think the secular viewpoint is gaining a lot more steam than it has in the past, and I think it's more persuasive to a millennial generation. I think.
Another question from the audience?
I'm not trying to put anybody down here, but I'm hearing a lot of, and I say this as a very strong believer in Jesus, I'm just hearing a lot of, because the Founding Fathers were majority Christians, then we should accept Christianity as a basis of morality, but they very clearly separated church and state in the Constitution. So, and these these guys weren't idiots. They were doctors, lawyers, very, very smart people, so they would have had to know that.
Well, they did all right for a bunch of old white males.
Who drank a lot and did other things that weren't necessarily in alignment with what we view as the traditional
I guess my
good
main
guy.
point is that they understood that, for the most part, that I think that while their ideas are nice, their philosophy is nice, that the government can't legislate moral things like homosexual marriage or things like that, because at the end of the day, if we're going to allow the Christians to only marry men and women, then we should allow men to marry men and women to marry women within the confines of the state.
Comments? Comments?
The truth is it's settled law now. So it's academic. And if we want to change it, it's a constitutional amendment. That's it. And I'm glad to see that try to happen, because I bet that debate's going to be fun.
Well, I think, I'm sorry, but I've spoken too much.
Oh, that's all right. I was just going to say that the U.S. Constitution is based on the early, drawn a lot from the early state constitutions, which there is a lot of Christianity in those when you look at all the references. And they're knowing that, and also looking at our early laws, our basic fundamental laws. They were based on English common law, which was traditions, centuries of court decisions that they said were in agreement with the Bible. So it's not just nice ideas. This was part of the whole fabric of our society and our law system. And all of our early judges and attorneys and statesmen studied William Blackstone. So it's very much an integral part.
I would posit the question, and I'll send it this direction, that really I think comes back to the ultimate question for the panel, which is, I mean, the fact that it was that way, does that mean and shall be forever? As though 300 years from now, when we don't know what the world will look like, do we now go back 500 years and say, well, it was a Christian society then, and now 500 years on, we can be inflexible? I mean, I'm asking, because I don't know.
Well, they weren't inflexible, giving us the amendment process to begin with. They didn't think it was perfect. They provided for it to be changed. They just wanted it to be very carefully considered. That's why they made it difficult.
Right.
It's not impossible.
And I think that's an important point right there. It is that their intent, the Founding Fathers' intent was, if there's going to be a change in the Constitution, it's going to be changed by we the people, not they the judges. And and I see, that is what I see as the greatest threat. It's not the changes that are being brought about by the people. It is changes that are being brought about by the judges, that where there's virtually nothing in the Constitution that they can find as the origins, and yet they make a statement as if it came down from Mount Sinai when it just doesn't exist.
Question in the back of the audience, young man.
On the topic of settled law and judges fabricating laws out of nothing, as with Dred Scott, how does precedent pertain to judges citing precedent instead of the Constitution? Is that valid? Are they supposed to do that?
Nick, you're the resident attorney.
Well, I mean, I'm not quite sure I follow your question.
Right.
Are you asking whether or not judges are bound by precedent?
Yeah, more or less. It seems certain.
Seriously, we don't have time to open that can of worms, because I felt like that was an entire semester of law school. Mac might remember. But the truth is that, to a degree, yeah. But when you get to the Supreme Court, we have to ask ourselves, what are they really trying to do? Comity of law is very important. Comity of law is that what is true as law in Texas is true as law in California, at least at the federal level, right? We want things to be relatively the same. And they're always trying to find a way to achieve some kind of equitable end that creates comity and that comports with the principles of the Constitution, whatever that may be. Judges are not like, they're not, it's not some kind of beer swilling frat club where they just make things up from the get-go. They are well-trained, well-educated philosophers, thinkers. They're people whose job it is to sit around and think about the law. So it's not dreamt up out of nowhere. It is a function of their study of the law, that they are able to interpret the facts as presented to them, apply them to whatever the law is, and in this case, it's the Constitution, and get a result. That's what we want them to do. We ask them to do that.
But yeah, with all due respect to my learned colleague here, we do have to throw in the mix of, is that person approaching the interpretation of the Constitution from a liberal or a conservative perspective?
I am confident that a lot of people who were big Bush fans were a little bit concerned about Justice Roberts' decision in the Affordable Health Care Act.
Right.
I mean,
Well, I think that was a prime example of where even supposedly conservative judges can get off base. In that, basically, what he said was, "Hey, everybody said it's not a tax, but it's a tax, and therefore they can do it." When the law said it wasn't a tax, everybody said it wasn't a tax. The people who were defending it said, "No, it's not a tax." And then he said, it's a tax. There is a prime example of him plucking one thing out of thin air. And so I think, if I could, one more point. I want to be clear when we talk about the separation of church and state, what we're really talking about, because our founding fathers couldn't have been clearer. It was, they wanted to avoid what they had in Europe, where they had state-run churches. It was never, the First Amendment was never designed to drive faith from the public square. The idea that we couldn't have prayer in school and stuff like that, we couldn't have the Ten Commandments in schools, because if the students read it, they might believe it. You know, things like thou shalt not kill and that kind of stuff. Then we can't have that because there's a separation of church and state. That is so far off path that it's not even funny. And they had, all they had for the basis of that was some previous court decisions. They did not find it in the Constitution.
We have time for one last question. Gentleman in the back.
So if we are leaving these, all these laws and whatnot to be interpreted by the Supreme Court and whatnot, and all the judges, wouldn't it make sense that we should not change the Bill of Rights? Because if we are then changing the wording of it so that we may understand it better, generations from now, when they may have a completely different understanding, instead of getting the original idea of the founding fathers, they're now getting our interpretation of the original ideas. So it would no longer be they would no longer get the opportunity to.
Excellent question.
Look at
Excellent question. Let's leave the historians to answer that question.
I'll say, I think you made an excellent point. I think that's a great question, and I'll say it also it could lead into a further discussion again we don't have time for. I mean, if we're going to change the Constitution, do we change the Declaration? Do we change these other documents and these things that we were based on, that were written in the same format, the same time frame, the same expectations, the same beliefs? I mean, if we're going to change the wording of this, should we change the wording of everything? And again, there is the fear of putting a little bit of our bias into it if we're not careful about how we word it, if we're going to change it. So I think that's a really good point.
That's a very good point. What was your opinion, Professor Jones?
Well, I would ask who would the we be, for one, because we, the American public, are deeply divided.
Are we the artificial intelligence?
And it does basically come down to a question of limited government or unlimited government. And it does seem like a lot of these calls come from those who want to get away from a limited government. And then, of course, there is always a danger in getting away from reading the primary sources, which, like the Constitution, the Declaration, and the Bill of Rights, most people don't even really know, have never, even though the Constitution's only 4.5 pages, and has been copied more than any other document in history for setting up new governments, limited governments, most of us have never read the whole thing.
Nope.
That's true. I agree with that completely. I want to clarify, when I said before that it's in theory changeable, that's on the assumption that it's not an infallible document. And if it's not infallible, then that means it could be fallible, right? You understand, infallible means it's without error, fallible means it could have some mistakes. Now, so on the basis of that, I think in theory it would be changeable. But I think you make a really good point and a really good case for why it shouldn't be changed for other reasons.
That's true.
Actually doing that allows for a broader, for a better avenue of interpreting and flexibility in the future than changing it. Because as we change it, we tend to harden. It's like kneading the dough too much. It becomes, it doesn't become malleable. It doesn't rise like it should. It becomes stale and flat. And
I don't know, Professor. My mother did that a lot, and the tortillas were excellent. We want to thank the panelists for taking time from their busy schedule today. I appreciate my colleagues doing that, and I appreciate the students coming out, and hopefully this was a learning experience for everyone, and I hope everyone equally enjoyed themselves. Thank you so much.